Good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, we are going to, I will address everyone in regards to whether or not probable cause exists on your case, and then we'll talk about release conditions. Today is not your trial date, so I encourage you not to talk about your case when you come up because everything in this courtroom is being recorded. For those of you who are represented by attorneys, if you have an attorney from the Public Defender's Office, in the courtroom we do have Attorney Brian Reedy, and over at the main jail there's another attorney from the Public Defender's Office. If you have a private attorney, they usually come to the courtroom and you'll be able to see them on the screen and they will speak on your behalf. Now, every morning I say, don't talk about your case. And then inevitably somebody comes up and says, I'm not going to talk about my case, but, and then proceeds to talk about their case. So what I would advise you to do is to speak with your attorney before you just shut off by itself. So I don't know. I turned it back on. Mr. Eric Linder, we have confinement status as well as pretrial services in case there's anyone to be released on the condition of pretrial supervision. So with that said, we're going to start this morning.
Your Honor, the main jail has requested a case be called out of turn.
And what case is that?
It is the very last case on your docket, page 26, Jeffrey Simmons.
Who's approaching Judge?
Okay. All right, Mr. Simmons, good morning.
Good morning, ma'am.
You are before the court today. It looks like he's back for a 48-hour perfection on count one. State.
Your Honor, I don't have anything additional to provide at this time. I would be asking that the court make a probable cause. I imagine the issue was
The age.
the age. I would ask the court to make a PC determination for.
We have, all right, we're back on. It keeps jumping off, so we'll see how, hopefully that's not going to be a trend this morning. All right. Okay, so count one was battery in a person 65 years or older. The state had 48 hours to perfect as to the 65 and over. Nothing being presented. I find probable cause only for battery at this time. And
Judge, we're going to be asking that the court consider setting $1,000 on the misdemeanor offense. My understanding he has a parole hold anyway, but considering it's a misdemeanor, I'm asking for standard bond on the misdemeanor offense.
Your Honor, I would also ask the court to take into consideration. I imagine Judge Lerner Wren took into consideration Mr. Simmons' lengthy history involving violence when setting a bond. His history includes 2014. Burglary of a conveyance of battery, armed kidnapping, aggravated battery with a deadly weapon, felony battery, domestic violence by strangulation, aggravated assault with a deadly weapon, violation of a pretrial release condition, no contact. He was sentenced to 5-year state prison as a habitual offender. 2014, aggravated battery with a firearm, possession of firearm ammunition by convicted felon, 5-year state prison as a habitual offender. 2013, felony battery, domestic violence by strangulation, aggravated assault with a deadly weapon. 2006, possession of firearm by convicted felon, 5-year state prison as a habitual offender. Strong arm robbery and aggravated battery, 04, a year and a day state prison as a habitual offender. 1998, burglary of a conveyance of battery, strong arm robbery, and battery on a victim over the age of 65. He was sentenced to 20 months in Florida State Prison.
all right, as to the count one, I am going to impose a bond of $2,500. I don't know if that was in place before, but if it's not, no victim contact. All right, good luck, sir. All right, there are some persons who have signed in. So I believe this is on page 17. Adriana, no. Who's on Clinton, Jean-Pierre on page 17.
Good morning, Your Honor. Scott Saul on behalf of Clinton Jean Pierre.
Good morning.
Mr. Jean-Pierre, come on up, your private attorney.
Judge, I believe my client was arrested on a warrant, so PC is not at issue.
All right.
I'm just seeking a bond. If you can issue the standard bond, please.
All right. State?
Your Honor, I do have a concern based on the allegations for the victim's safety. It is, as mentioned in the report, he does have an open case at a date, tampering with a witness or victim in a life or capital felony, 2 counts. I see arrests in 2014 and 2013 for aggravated battery that were dropped. Your Honor, possession of cocaine in 09 that was pled out. I bring up the aggravated batteries because of the domestic nature of these allegations. I see another arrest for aggravated assault with a deadly weapon in 2010 that was dropped. Another arrest for aggravated battery with a deadly weapon. 4 counts of shooting at or throwing a deadly missile, battery and child abuse in Dade that were dropped. A strong arm robbery and attempted burglary of an occupied dwelling that was dropped. And an aggravated assault with a firearm last year that was dropped. I'm going to be requesting a $50,000 bond on count 1, pretrial release with a GPS monitor and no victim contact.
Judge, if I can respond, please.
Certainly.
The 2 witnesses in this case have petitioned for an injunction, so that takes care, along with any condition that you provide. I think that takes care of my client staying away from them. My client in this particular case is not accused of any violence, so I think what the state is asking as far as the amount of bond is very excessive. I think a standard bond, perhaps in the amount of $5,000 or $10,000 with a stay-away order, I think would be sufficient for this particular situation. My client is not accused of laying his hands on anybody.
Your Honor, there are multiple allegations of violence in this affidavit, and one could argue the reason he was unable to put his hands on the victim is that he was unable to kick down her door, which there was physical evidence of him attempting to.
Okay. I have read the probable cause affidavit. I do find that there are concerns for the community. The allegations are more than once that Mr. Jean-Pierre is allegedly at the door, banging it down, calling the police, telling them, giving them information that the alleged victim was being raped, and that's why he was calling them, that he called a locksmith to change the locks so that he could try to get in the house, that there was an allegation of over a period of 40 minutes that he called her 53 times. And so based on those allegations, I do find probable cause as to aggravated stalking and possession of cannabis 20 grams or less, and I am going to impose a bond on count 1 of $30,000, no victim contact. Sir, that means no phone calls, no text messaging, no asking anyone to go to the home, and then I'll also impose a $1,000 bond on the count 2. If Mr. Jean-Pierre is able to post his bond, he'll also be on pretrial supervision with the GPS.
Thank you.
Thank you, Mr. Sir. Okay. All right, and also on page 4, there was Adriana Burris.
Good morning, Your Honor.
Good morning.
On behalf of Ms. Burris.
Good morning.
Come on up, there's your private.
Good morning, Mr. Marvin.
Your Honor, this is also a warrant case, so probable cause is not an issue. I'm asking the court to set the standard bond. I surrendered Adriana yesterday at the Wilton Manors Police Department. The allegations in this case date back to an incident that occurred several months ago. My office and Ms. Burris cooperated with the police investigation, provided a witness that was there and saw what happened. the state attorney's office decided to pursue this charge, filed this warrant, and the detective contacted me, and I surrendered her. She's 19 years old. She has no prior criminal history. She lives with her parents, who happen to be personal friends of mine, as an aside. She's not a danger to anyone. This is an isolated incident that happened between two young ladies who had a disagreement, and we feel she was defending herself. The state attorney's office feels otherwise and filed this charge. She's a U.S. citizen, and again, no prior, so the standard bond, I think, is more than appropriate in this case.
Okay, State?
Your Honor, I'm going to be requesting a $20,000 bond, no victim contact, and again, this, because it does appear that both parties know one another, pretrial with a GPS monitor. I would note that there were independent witnesses that don't appear to know either party that corroborated the allegations. Your Honor, I would also note I'm making this request based on not only the level of harm in this matter, and you can see the victim was stabbed in the head. Hospital personnel indicated if the knife had hit the temple that it could have caused brain trauma to the degree that the victim could have died. Your Honor, I would also note statements taken from Ms. Burse's girlfriend that she is known to carry blades. So I do believe there is a level of danger to the community.
Your Honor, again, this incident occurred several months ago. There's been no contact between Ms. Burris and the alleged victim in this case. There have been no further incidents. So, I think it's an isolated incident. Whatever happened that day only. Obviously, we're going to flush it out in court in the future, but in terms of there being a danger to the young lady who was the victim, months and months have passed, no contact, no further incidents. I don't believe there's need for GPS in this case. I think a bond is sufficient.
All right, I do find probable cause as to aggravated battery. Based on the allegations, I am going to impose a bond of $10,000 and no victim contact.
Thank you very much. Have a great morning, Judge. Thank you.
All right. So let's go back to the top. Norma Caldera.
North Broward.
Your Honor, good morning.
Good morning.
Caldera is downtown court.
Okay. All right, we'll have to reset Ms. Caldera. Thank you.
You're welcome.
Did you speak to her? You spoke to her?
No, I didn't.
Oh.
Explains why.
Oh, okay. Centrella Floyd.
She's here present, Judge, and May.
All right, Ms. Floyd, you are before the court this morning for one count of criminal mischief, and I do find probable cause. And I'll hear from the parties as to bond.
Judge, in speaking Ms. Floyd, I should advise her bond is $100. She did give me a phone number of her family for me to contact. So at this time, nothing to request on Ms. Floyd's behalf.
All right, your bond is $100. Good luck. All right, on page 19, Tony Walden, Attorney Greg Lauer. Good morning, Lauer. Good morning.
Lauer on behalf of Mr. Walden. Waiting on him.
Yes.
One moment, Judge.
Thank you.
Judge, I believe the people that are here are up to page 17.
Yeah,
So
they're
the deputies are going to go bring Mr. Walden
okay.
in right now.
All right, depending on where they are,
I got you.
they bring them in groups now.
Your Honor, North
Okay.
Broward is asking for a case to be called out of turn. Toward the very end of the court's docket on page 24, Jerome Shaw.
No problem.
All right, Mr. Shaw, you are before the court today for some add charges. Charge number 6 is burglary, unoccupied conveyance, unarmed. Count 7 is petty theft, and count 8 is illegal use of credit card more than 2 times in 6 months to purchase goods. I do find probable cause as to those 3 counts, and so I'll hear in regards to bond.
first name? What's his first name?
Okay. Does the state wish to be heard?
Your Honor, no, Judge.
All right. So, Mr. Shaw, on count 6, your bond will be $1,000. 7, the bond is $25. 8, it's $1,000. Good luck, sir. All right. Once Mr. Walden is in, you can let me know, okay?
I will, Judge.
Catherine Wilson,
North Broward.
North Broward, Your Honor, she's still in transport, so we have to locate her and bring her here.
all right, as soon as she's in, you can let me know. Thank you.
You are.
And Judge, Mr. Walden is here.
All right.
Come on up, sir. Mr. Walden, there's your private attorney, okay? Click down the screen bottom center.
Hey, Tony.
All right, Mr. Walden, you are before the court today for charge number 1 is carrying a concealed firearm, and count 2 is not for magistrate, it's a traffic infraction. I do find probable cause, and I'll hear from the parties as to bond.
Judge, I've known Mr. Walden for 12 years. I know his entire family. His daughter graduated from Barry. His son just graduated from South Broward. Been out to dinner with him and his wife. He's not a flight risk. He had, I think, one prior from 1996, which I sealed, which means there are no other priors anywhere. I'd ask just for an ROR. He's lived in Hollywood his whole life. He's not going anywhere. I'm here to take care of him. This is the type of case where an ROR is just fine. He's going to show up. He doesn't need pretrial, and he doesn't need to pay a bond when he get out. I mean, his whole family's here. I know his brothers. You know, his grandma just died. She was local. He's not going anywhere.
State, do you wish to be heard?
Your Honor, just to advise the court, and this is separate from what I believe this might be separate from Mr. Lauer's referring to. He had a offense in '92 that involved a weapon. It appears to be a firearm.
Is that the one I got sealed?
It doesn't mention that it was sealed.
Okay. I sealed one from him, which I know is from the 90s, Judge, and so I think it must have been that one. Because I remember he was having some issues getting work. He was working in a nursing home, and they, wanted something sealed. And so I took care of it with FDLE.
All right, I do find probable cause. I'll
Judge,
grant.
he has had a concealed weapons permit in the past. I don't know why he let it lapse, Tony, but, it's just in a bag, in a holster, under a seat, legally owned by him.
I am granting the ROR.
All right, thank you, Judge. I kept going a little bit. Sorry about that. All right, Tony. I'll talk to you in a little while, okay?
Amadra Duncan.
Yes.
Ms. Duncan would like to resolve this matter this morning, if possible, Your Honor.
All right. Ms. Duncan, you are before the court for one count of trespassing, and I do find probable cause. Your attorney tells me that you wish to resolve your case today. Is that correct?
Yes.
All right. State, do you have an offer for Ms. Duncan?
One moment, Your Honor.
I was like, oh.
Offer would be withhold court costs.
Okay.
What you'd like to do, Ms. Duncan? Enter a plea of no contest. You'd have no conviction on your record, but you'd have to pay court costs and stay away from wherever you were arrested.
Yes.
Okay.
All right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah.
Okay.
Yes.
Okay, you can put your hand down. Ms. Duncan, do you understand everything that's going on here today?
He said that I plead no contest, meaning that I can't go back to that store, and
There's no bond. I'm trying to understand. Will I have a bond or?
No, it seems like you understand well. You are resolving the case today, so there will be no bond.
So I'll be going home today.
If there's nothing else holding you in custody, yes.
Okay.
All right.
Thank you.
Do you need more time to speak with your attorney?
No, thank you so much for everything.
All right.
You're very welcome, Ms. Duncan.
All right.
That's always a good way to start the morning. We're not done yet. Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
Yes.
Are you taking any medications that would affect your decision today?
No.
And you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
I'm a citizen.
All right. What plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is withhold adjudication and court costs. And Ms. Duncan, no return to the U-Save convenience store. Do you understand that, ma'am?
Yes.
All right, good luck.
Thank you.
Gloria Eubanks.
Judge, she's here present Maine. She informed us she has private counsel. I don't know if my colleague had an opportunity to call and reach out to her.
I did call and left a message. I have not heard back. Let me try him again.
Okay. All right, we can recall Eubanks. And then Jessica Martinez.
Paul
I
Ryan.
believe Paul Ryan.
All right, Your Honor.
Thank you. Ms. Martinez, you are before the court today. Counts 1 and 2 are felony KPS matters. Those are no bond holds, not for magistrate. And then you have 2 felony violation of probation. Those are no bond holds as well. And then 5, 6, 7, and 8 are violation of pretrial on felony matters. I do find probable cause. You will be before your felony division, FD division tomorrow at 8:30. Good luck, ma'am.
Thank you.
Antoinette Bellamy.
That's right, Your Honor.
All right, good morning, Miss Bellamy. Ma'am, you are before the court for me to let you know that there's an out-of-state felony hold for you. That's a no bond hold, and so you should be going to extradition court. Today's Tuesday, so Thursday or next Tuesday, because they have extradition only on Tuesday and Thursday. So you'll be before the extradition judge shortly, okay? All right, good luck. Althea Poole.
She's approaching, Judge. She's here at Maine.
Ms. Poole, you are also before the court because of an out-of-state felony hold. I do find probable cause. It's a no bond hold. You will be before the extradition court also shortly, okay?
Broward advises they have Miss Wilson, Your Honor.
Okay.
No problem.
All right, thank you. Catherine Wilson. Ms. Wilson, you are before the court for soliciting in traffic without a permit. I do find probable cause. What does Ms. Wilson wish to do?
Didn't get a chance to talk to her, Judge, because she was in transit, but Catherine, are you interested in resolving this today?
Yes, I am. Please.
Maybe if we could get an offer from the state from Miss Wilson.
Offer be time served.
Is that what you'd like to do, Miss Wilson? Time served?
Yes.
Okay.
All right, ma'am, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, you can put your hand down. Do you understand everything that's going on here today?
Yes.
Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
And is there anything about that today that's making you not able to make a decision today?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, ma'am, is adjudication and time served. I'll give you 6 months to pay your court costs. Good luck.
Thank you. Have a good day.
You too. Markison, Saint-Hilaire. We have Mackeson, Saint-Hilaire.
Yes, Judge, he is here. I believe he just stepped out to the restroom.
All right, well, we call him when he comes in. Gregory Pierre.
Mr. Pierre, come on up, please.
Mr. Pierre, you are before the court today for 1 count of aggravated battery with causing bodily harm. I do find probable cause. And I'll hear from the parties as to bond.
Your Honor, the state would be seeking a $10,000 bond, no victim contact.
Does Mr. Pierre have priors?
I don't see any, Your Honor.
Okay.
Judge, this is a problem. As far as speaking, Mr. Pierre, unfortunately, when he was arrested, he didn't have his phone with him, and he doesn't have any numbers memorized in order to call his friends to post his monetary bond. We're going to be asking for the court to consider releasing him on level 2 GPS. Judge, he's 36 years old. He's working. He works at Broward General Hospital as a security guard. He's been doing that for the past year, making about $13 an hour. He lives in Lauderdale Lakes, where he's been renting a room for the past 3 months. His rent is approximately $550. And most importantly, Judge, as you heard, this is his first contact with the criminal justice system. Him and the alleged victim do not live together. They live apart. I did advise him that the court will be imposing a no-contact order. He has no problem adhering to that no contact. But like I said, there's no one that can post his bond because he has no numbers memorizing. And that's why we're requesting a level 2 on his behalf.
Based on the allegations, I do find probable cause. I'm imposing a bond of $5,000, no victim contact.
Judge, would you sign a photo order as well?
I will.
Thank you, Judge. And Mr. St. Hilaire is back.
Okay.
Mr. St. Hilaire, come on up.
All right, Mrs. Saint-Hilaire, you're before the court for count 1 is touch or strike battery. Count 2, it's a felony violation of probation, which is a no bond hold. I do find probable cause.
Judge, considering it as a no bond hold, we're asking for $1,000 on the misdemeanor battery on count 1.
I'll impose a bond of $1,000 on count 1. He should be before his division judge tomorrow at 8:30.
No victim contact, Your Honor?
No victim contact. All right. Franklin Blumberg.
He's here, present, Judge Emmanuel.
All right, Mr. Blumberg, you are before the court. Count 1 is touch or strike battery. Count 2 is felony violation of probation. That's a no bond hold on the violation, and you should be before your division judge tomorrow at 8:30 on that count. I do find probable cause.
And Judge, considering no bond hold, we're requesting $1,000 on count 1.
Order no victim contact and $1,000 on count 1.
Court liaison.
Anthony Adon.
I think he's a medical loan, Judge.
He should be back.
He's been for a few days. Is Anthony Adon back?
No, ma'am.
All right.
Medical loan.
Thank you. All right, Raymond Blackshear.
Your Honor?
Conti?
I'm sorry.
I'm sorry, Mr. Adone, has a PC determination been
I
made?
think so. Let me see it. I think he, hold on. Well, it wasn't separated. Whoever was here signed it, but I don't think it was, I don't think it's official. So, are you asking for a PC? Does the Public Defender's Office represent him? Anthony Adon?
I don't know.
He's not here, I know, but we're just.
Thanks.
Okay. Any objection to me finding probable cause?
Objection.
All right. So as to Mr. Adon, we'll find probable cause as to the 4 counts, and well, he needs to be brought back for bond determination. All right. We can go to Raymond Blackshear.
Conti?
Thank you. All right, Mr. Blackshear, you're before the court. This is an ad charge, charge number 4. What is the charge? Oh, no, this is a no-show for, what does it say? Oh, sorry, looks like you failed to appear in court on January 7th of this year. You did not show up for arraignment on an operating with a suspended license charge. So I do find probable cause. You do have court tomorrow. Well, yes, you have court tomorrow at 9 a.m., so what does he wish to do?
Well, Judge, he has a total bond, it looks like $750 on count 1, $500 on count 2, and $100 on count 3.
Okay,
So I'd ask the court maybe to consider a $100 bond on count 4.
Your Honor, he's already had 3 other cases. His judge, who he's supposed to appear before, decided a $500 bond was appropriate. I believe he's seeing his judge tomorrow. I'd ask that the court leave the bond where it is.
all right, Mr. Blackshear, your bond is $500, and you do see your division judge tomorrow, okay? Hippolito Mata?
He's approaching, Judge. He's coming up, Mr. Mata.
I apologize, Judge. He bonded.
Oh, okay. There's some persons that are represented by Mr. McLawrence. We'll call those when he gets here. Then there's, so we're gonna skip Joseph and Jackson, and we're gonna go to Anthony Pickett.
Mr. Pickett? Come on up, sir. I'm waiting for Mr.
All right, Mr. Pickett, you are before the court for touch or strike, battery, and count 2 is criminal mischief. I do find probable cause.
Judge, I did speak to Mr. Pickett earlier today regarding the $1,000 bond on misdemeanor offense. Unfortunately, from what Mr. Pickett advised me, he is not in a position to post bond, and he lives with his mother in Tamarack. She's retired and on Social Security, and she cannot afford to post his monetary bond. And speaking with Mr. Pickett, he's been here his whole entire life. He's 43 years old. He works doing everything, handyman, landscaping, construction. But from what he told me, he doesn't have the financial resource to post a monetary bond. Now, he did advise me he has prior contact with the criminal justice system, but it's been a couple of years. So from what he advised me, he's been clean for a couple of years, Judge. That's why we're asking for the court to consider releasing Mr. Pickett on standard pretrial release.
What do you know?
The state wish to be heard?
One moment, Judge. Just note, he's been in the state prison. He was most recently released in 2016. He's been qualified as a habitual offender. Most recently, when he went to state prison, he was battery on a law enforcement officer, resisting with violence with a trespass. A lot of trespasses in the past. 08, resisting with violence, 30 months state prison as a habitual offender. I'm showing he's been sentenced to state prison on 9 occasions.
So as you can see, Judge, he's been clean for about 3 years, if my math is correct.
All right, based on the allegations in the affidavit, I will, level 2, pretrial supervision.
Is there any more information or detail?
All right, we're gonna go past 3 and then go to Mr. Rocco Del Ciotto.
Mr. Del Ciotto is here present, Judge. Go on up, sir.
All right, Mr. Del Ciotto is before the court for a misdemeanor capious matter. The charge is failure to obey officer, and he did not show for his arraignment on March 26th. So,
Judge, in speaking with Mr. Del Ciotto, he wishes to ask the court if the court would consider resolving this matter today.
all right, State, is there an offer?
Hold on. Deputy. Who's this, Your Honor?
Del Ciotto?
Adjudication time served. I understand. I'm just letting you know.
The offer is time served.
Yes, sir. Please, Judge, he wishes to accept this.
All right, sir, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir.
You can put your hand down, sir. And do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No, Your Honor.
And do you need more time to speak with your attorney?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
You understand you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
In the past, many years ago.
And is there anything about that will make you not able to make a decision today?
No, Your Honor.
Do you understand that if you're not a U.S. citizen, that by taking a plea it could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Good luck. Thank you.
All right. All right. Fabian Lyon.
He's approaching, Judge.
All All right, Mr. Lyon, you are before the court this morning for trespassing, and I do find probable cause. What does Mr. Lyon wish to do?
He wishes to resolve this case today.
All right, Mr. Lyon, State, do you have an offer for Mr. Lyon?
If the offer would be time served, Your Honor.
All right, Mr. Lyon?
Judge, he wishes to accept the state's offer.
All right, Mr. Lyon, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yes.
All right, you can put your hand down. And Mr. Lyon, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
And do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And you understand you have a right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
And have you ever been treated for mental or emotional illness?
No, yeah.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, Mr. Lyon, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Thank you.
All right, Mr. Shate has a few, so we'll take some of those.
Thank you, Judge.
All right, on page 14, Christopher Backman.
Your Honor, hold on 1 second. I have to wheel him in.
Okay, who's that, North Broward?
Yes.
Thank you.
Come on out.
Okay, Mr. Backman. Mr. Backman, you are before the court for it's 7 misdemeanor KPS matters. They are both municipal ordinance violations as well as state violations. It's sleeping in public, it's trespassing, it's sleeping in public, it's open container, open container, open container, open container. And so I do find probable cause as to all those counts, Mr. Backman. What does Mr. Backman wish to do?
Plead no contest.
Judge, you'd like to resolve all 7 matters. The city of Hollywood is sort of on the cusp as to what they want to do with him today, based on the number of charges. They said they would leave it to the courts.
All right. Mr. Backman, if I know you said you want to plead no contest, but I also want to let you know that I will sentence you to adjudication and time served on all these counts. Do you understand that?
Adjudicated?
And time served.
Okay. Yes, ma'am.
All right. But I also want to tell you that all these places where you've been trespassed from, where you've been sleeping in public, that you are not to return to any of these places. Do you understand that?
Yes, ma'am.
You know, while the final decision is with me, based on what your attorney is saying, is that the city of Hollywood, is it Hollywood?
Yes,
yeah.
The city of Hollywood, you know, next time they're going to come in here and ask me for a more serious sentence because of the number of violations that you have. Do you understand that? All right, so you may need to try and find some shelter or some organization that can help you to find place to live or to sleep.
Yes, ma'am.
Okay, do you understand that?
Yes, ma'am.
All right, Mr. Backman, if you can, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Do you understand everything that I've said to you, Mr. Backman?
Yes, ma'am.
Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And Mr. Beckman, have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yeah, I'm American citizen.
Okay. What plea do you wish to enter?
No contest.
All right. I accept your no contest plea, sir. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. And I am making a note that I told you not to return to those locations where you've been sleeping or hanging out. Okay?
Yes, ma'am.
All right. Good luck, sir.
Thank you, ma'am.
All right. James Soderland on page 15.
That's me, Joe. James Soderland?
Okay, good.
How you doing, James?
Good morning, Mr. Soderland.
Good morning.
All right. Can you see your attorney on the screen?
Yes.
All right. You are before the court today for a municipal ordinance violation, and I do find probable cause. What do you wish to do today, Mr. Soderland?
Just pleading no contest.
All right.
Judge, it's a Pompano case, state offer time served.
All right. So, Mr. Sutherland, I'm going to sentence you to adjudication and time served. Okay, good luck, sir.
Thank you, sir. Thank you.
Mark Roser. On page 15. Good morning, sir. Good morning. You are before the court for municipal ordinance violation. It's an open container. I do find probable cause. What does he wish to do?
Judge, they would offer him a time served plea.
All right.
No contest?
Hold on.
All right. Then I'll accept your no contest plea, sir, and your sentence is adjudication and time served. Good luck.
Thank you very much.
All right.
They can only all be.
Did you have a Mr. Greenstein?
Judge, he evidently, do you don't have the paperwork? Is that correct?
Yeah, we don't have that. Okay.
Is he there though, or should we address him?
I don't, what's his first name?
Is Alan.
Is
Alan Greenstein?
Do we have an Alan Greenstein? No paperwork, so he wouldn't be there. Thank you.
Thank you, Judge.
All right. All right. Trey Sutton. All right, Mr. Sutton, you are before the court for false ID given to law enforcement officer. I do find probable cause.
Mr. Sutton.
Page 12.
Thank you, Judge. I found Mr. Sutton. Judge, in speaking to Mr. Sutton earlier today, my notes indicate he wanted me to ask the court if you would consider resolving this matter today.
All right, State, do you have an offer?
Adjudication, time served.
Does he have priors?
He does. He's been to prison, released last year.
Okay.
Just to accept the state's offer, Judge.
All right, Mr. Sutton, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Sutton, do you understand everything that's going on here today?
Yes, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you do have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Sutton?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Good luck, sir. For this one.
All right. We're going to go past Jesse Roberts, and then the next person we'll call is Fitzroy Morton.
He's approaching, Judge.
Mr. Morton, you are before the court today for 2 misdemeanor capias.
There's 2 of them?
Yes, it's for each charge. One charge is battery and the other one is disorderly conduct. And looks like you did not appear for arraignment on January 31st, and so I do find probable cause. And, yes.
Speaking of Mr. Morton, from what he advised me, he received a letter of information that there was an outstanding warrant for his arrest. So what he told me is he actually went to the clerk's office last week to find out more information. Sure enough, he did find out he missed a court date. What he tried to do is reschedule the court date. So what I'm going to be asking is if an odyssey reflects that, to consider releasing Mr. Morton ROR. I did advise Mr. Morton, however, if the court's not inclined, he will be seeing his judge tomorrow morning.
Can I say something to you?
One moment. And Judge, from what he told me, he gave me further information as far as his encounter with the clerk's office when he went last week. They told him that they actually sent no mail, but then in the same screen, from what he was advised, the letter was returned back to sender. He does not know why, but he never received that notice, and that's why he went to the clerk's office to try and straighten things out.
Well, did he check the address that the clerk have at the time that he was there?
No, I didn't. They didn't tell me what the issue was, why the letter was sent back. They just told me it was sent back.
Your Honor, Judge Carpenter-Toy got the request. She's had a status conference set for the 26th, but she didn't waive the or delete the capias. She kept it in place. That's a conscious choice she made. It's her case. It's a battery. I'd ask that the bonds be left in place.
He had a status conference on the 26th.
Set for the 26th.
Set for the 26th?
Yeah, I imagine if he didn't get picked up on the capias, but she left the capias in place.
It does show he requested a file. He filed a form on March 28th. And it was sent to the judge on March 29th.
That's what I just said.
Yeah. So what he said is true.
Yeah. And it's also true that Judge Carpenter-Toy, given the option, said the KP should stay in place in the amounts that she said.
All right. You do go to court tomorrow in front of Judge Carpenter-Toy. So based on that, I'll just leave the bonds in place and you'll have that conversation with your judge tomorrow. Okay? All right. Patrick Wilson.
Mr. Wilson, municipal ordinance.
I'm waiting for your turn, Mr. Wilson, so I'll recall your case, okay? Just have a seat for a moment. James Scholar.
Mr. Scholar, come on up, please. He's approaching, Judge.
All right, Mr. Scholar, you are before the court for obstructing highway, and then there's a misdemeanor KPS for a petty theft charge that was issued on January 10th. I do find probable cause. What does Mr. Scholar wish to do?
Judge, this being Mr. Scholler, he wishes to resolve both matters today.
Say, do you have an offer for Mr. Scholar?
Case.
Adjudication and time served. That's being offered.
Judge, this being Mr. Scholler, he wishes to accept these statements.
Okay, sir, as best as you can, please raise your right hand.
Please raise your right hand is what the judge said.
Right.
He has a little hard time hearing, Judge.
Okay, sir. Do you understand, do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down.
What?
You can put your hand down. Do you understand everything that's going on here today?
What?
Do you understand everything? What's going on?
Oh, yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
All right, I'm a U.S. citizen.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. Kuntal Choksi.
I've been advised he bonded, Judge.
Thank you.
I'm sorry?
Andre Gagné.
Mr. Gagney, come on up, please.
Mr. Gagné, you are before the court. Count 1 is resisting officer without violence. Count 2 is disorderly intoxication. Count 3 is a municipal ordinance violation for public consumption in the city of Hollywood. I do find probable cause, and what does Mr. Gagné wish to do?
Judge, it's me, Mr. Gagney. He wishes to resolve this case today.
All right. State, do you have an offer for Mr. Gagné on the...
On 1 and 2, it'd be the adjudication time served. Looks like 3 is the municipal ordinance.
Right. Mr. Gagné, if you wish to resolve, the sentence will be, for all charges will be adjudication and time served.
He wishes to accept the court's offer.
All right, sir. As best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Gagné, do you understand everything that's going on here today?
Yes.
And do you need any more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
All right. And you understand you have a right to go to trial, but by taking a plea today, you're giving up that right.
Correct.
What plea do you wish to enter, sir?
No contest.
All right. I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. On all 3 counts, yes. Michael Young.
Mr. Michael Young is here, Judge.
All right, Mr. Young, you're before the court for a trespassing charge, and I do find probable cause. What is this?
Judge, in speaking Mr. Michael Young, he wishes to resolve this case today.
All right, state.
Communication time served. No return. Your Honor?
He wishes to accept the state's offer.
Is he registered? One moment, Your Honor. Hot file, go. He should be aware, Your Honor, he is registered. He's a registered sex offender. And taking this plea could result in involuntary civil commitment.
Judge, at this time, I'll let the judge know. Judge, I just informed him because of his prior, he may be subject to Jimmy Rice proceedings. I did advise him that basically I nor this court have any control over it. And at this time, though, I told him I could ask the court to consider an ROR, considering this is a trespass offense. But he insists and wants me to ask the court to consider resolving this case today.
All right. Based on what I've been told today, I don't think it's prudent to resolve this case at first appearance. I am going to leave the bond at $100. Good luck, sir.
Judge, would you consider an ROR?
No.
He's homeless, financially indigent.
No. I'm denying that his bond is $100. Wayne Costello.
Conti, Your Honor.
Mr. Costello, you are before the court. These are two add charges. Charge number 17, dealing in stolen property. And charge number 18 is false owner information for pawn items less than $300. I do find probable cause. I suspect.
Mr. Costello has a no bond hold on count one.
All right.
That has the court to leave the bonds in
So
place.
the bonds will remain in place, $3,500 and $1,000. Good luck, sir. I find probable cause in case I didn't say that. Alfonso Davis.
Mr. Davis, come on up, please. Oh. He's here present, Judge.
All right, Mr. Davis is before the court for count one is possession of cocaine and count two is possession of drug paraphernalia. I do find probable cause.
Judge, in speaking, Mr. Davis, he did give me the phone number of his friend that he advised me will be able to post his monetary bond. That's, Mr. Davis said that shouldn't be a problem as far as the monetary bond.
All right, his bond is $1,000. Kimar Downey.
I'll probably be out of here in about an hour and a half. I'll call your friend George, okay?
See if you can get home. Yeah. Time served or something.
What's your name?
Judge, if you want to recall Miss Eubanks on page 4,
All right, as soon as I'm done with Mr. Downey.
Sure.
Mr. Downey, you are before the court for count one and counts 1 and 2, battery on an officer. Count 3, disorderly conduct. Count 4, resisting officer with violence. Count 5, resisting officer without violence. I do find probable cause as to all those counts. As to bond?
Your Honor, I'm requesting a $5,000 bond on count 1, $2,500 bond on 2, $1,000 bond on 4. Mr. Downey is currently out on bond for burglary of a dwelling, possession of cannabis, and DWS habitual offender. The state has filed a notice of intent to qualify Mr. Downey as a habitual offender in that case. His additional history includes 2015 sell or offer for sale counterfeit items, 2009 DUI property damage with enhanced breath, 08 fleeing and eluding, DWLS, 07 possession of cannabis with intent to sell, 03 strong arm robbery with a violation of probation.
Judge, and speaking of Mr. Downey, he's been living in our community for over 22 years. He's 34 years old. He is employed. He works for a company called Jones Awning, where he's been working with them for about 2 years, making approximately $12 an hour. Now, he lives in Coral Springs. He's been residing there for about 2 years. The person he's going to be reaching out to help post his monetary bond is his mom, but from what he informed me, she's retired on a fixed income, so she's not going to be able to afford the bonds that the state is suggesting. What I'm going to be asking the court on counts 1 and 2, which are third-degree felonies, $1,000 on each count, and on count 4, the $1,000. So we're going to be requesting 1,000 on 1, 1,000 on 2, 1,000 on 4, Judge. And we're going to be requesting a photo order, Judge.
All right, I do find probable cause as to count 1. I'm going to impose a bond of $2,500. Count 2, $1,000, and count 4, $1,000. And then the other bonds remain in place. All right, good luck, sir. Oswald Lucardo. Oh, I'm sorry. Hold on just a moment. Eubanks is at...
She actually is in the restroom right now, Judge. We
Okay.
missed our window of opportunity.
All right. Oswald Lucardo.
Mr. Lucardo is represented by Mickey Roque, who is available to appear by phone from Europe.
Your Honor, this was, just to let the court know, this was booked incorrectly.
Yes. Because it's just aggravated assault?
Yes, ma'am.
Right. So Mr. Roque wants
Okay,
us to
keep
give
me
him a
posted.
call?
By the way, that guy doesn't represent her, so.
All right, what's the number for Mr. Roque?
Okay, we're going to contact your attorney, Mr. Roque, right now. Okay?
Mm-hmm. 854?
No, I know.
Uh-huh.
Served.
Hello, Kiki.
Good morning, Mr. Roque. This is Judge Jackie Powell. How are you?
Oh, hey, Judge. How are you on the other side of the world?
I see this. You have a client that's before us this morning, Oswald Lucardo,
Yes.
and I heard that you wanted to appear by phone, so I'm making this phone call.
Thank you so much.
You are
Thanks
welcome.
so much. I didn't have a chance. haven't had a chance to review the probable cause affidavit. Is it possible, perhaps, maybe, if you could, Mr. Reedy could text me a picture of it to my cell phone, I could read it, and then you could call me back in about 10 minutes?
I don't have a copy of it, Mickey.
Yeah, that's a lot, Mr. Roque.
Oh, sir. Well, Judge, hey, listen, I've known you for many years, and I trust you. Do you think there's PC?
I'll tell you that there's a probable cause affidavit. There's what has been submitted for my review says aggravated assault on an officer, but there's no officer, so I'm finding a PC for aggravated assault. And so, based on that, I'm going to hear from the parties as to bond.
And Judge, is there a weapon or no weapon?
Firearm.
There is a firearm that he allegedly told the person that he would shoot them as he.
Who's the victim?
The allegations are that he inserted the magazine in a black handgun, racked the slide back as he stuck it out the window, and then said with the words, he'll shoot the person's name is, the last name is Barnia. All right.
Was that person even anywhere around? If that person wasn't even in the area, then there couldn't have been an assault because nobody was being assaulted because they weren't there.
Right.
You know what I mean?
Right, but the
You
person.
can't like assault the air, like, hey, I'm going to get Bernia. And then there's no person with Bernia. That's like improper exhibition of a firearm, I would think. I'd be PC for improper exhibition unless there's more to it. On improper exhibition, that's a misdemeanor. So I'd ask for a $100 bond then.
No, I think when you come back, you'll be able to make your arguments or file your motions. I'm finding for aggravated assault. So, State?
Okay.
Yes, Your Honor. Well, just want to see one thing here. Okay. Your Honor, I'm going to be requesting a $15,000 bond. No victim contact, no firearms, weapons, pretrial release with a GPS monitor. I would note, yeah, well, it's been taken off of him, Michelle, and you guys don't have to hold on him. Your Honor, I would note on February 11th of this year, Mr. Lucardo was placed on pretrial release supervision with a GPS monitor for an open 2017 possession of THC that's in drug court before Judge Porth. On March 19th of this year, Judge Porth signed a warrant for violation of pretrial. The basis is he left his residence without permission. Actually, he didn't comply with curfew on 2 occasions, and he failed to report 2 times per week as agreed upon and ordered. Judge Porth on March 20th signed a no-bond warrant. It apparently has not been placed on him by the Broward Sheriff's Office. I don't know why, but there is a current no-bond hold for him on that matter.
Okay.
Actually, Judge, that's close, but the rest of the story is he went to court yesterday, and the judge put him back on the EM with a different curfew because he's doing better in treatment right now. So I'd ask if you find probable cause, and I understand, I'd ask that you set the bond at $5,000 with pretrial release, same conditions that he's currently on.
All right, so you're saying that his pre-trial was reinstated? Are you saying that his pre-trial was reinstated yesterday?
Yes, we had court yesterday for his hearing his status hearing in drug court with Judge Porth. I appeared by phone.
Okay.
So,
what kind of vacation you're on that you're appearing by phone every day? I don't understand.
I know, it kind of stinks. I tried to reset all these cases, but Judge Porth was too busy last week. and he couldn't accept me. So, but he's nice already if you're on my phone.
All right, Mr. Rook. I do find probable cause. I am going to impose the bond of $5,000 with the same conditions as he's on for pretrial on his other case, and I'll say no victim contact, okay?
Sounds like a winner, Judge. Always
GPS.
a pleasure. Have a great day. Thank you so much
All
for
right.
calling me. Thanks, Mr. Reedy, as well for me. Thank you.
Enjoy your vacation. Hopefully you're not calling in another day.
Yeah, I bet I will, but you're good. Okay, have a great day. Thanks so much.
You're welcome. Good day. All right. Kevin Richard.
That's right, Your Honor.
Okay. All right, Mr. Richard, you are before the court for making a false report of bomb, explosive, or weapon of mass destruction. I do find probable cause. And I'll hear from the parties as to bond.
Your Honor, at this time, without having more information about Mr. Richard and just looking at the allegations on their face, I'm requesting a $50,000 bond, pretrial release with a GPS monitor level 1, release condition that Mr. Richard is not to be in possession of any firearms, weapons, or ammunition, or any explosive devices.
Judge, Mr. Richard is not going to be able to post that kind of a bond. He's been living here all of his life. He's been living with his parents all of his life. He indicates to me he has never been arrested before, and we'd be asking the court to consider a non-monetary bond. He is, unfortunately, in a wheelchair due to a car accident several years ago. So he's not able to really work and save up some money to arrange for his own bond.
Okay, and do we have any mental health concerns?
Well, we've never represented him before, so I have nothing to go by other than my conversation with him and the language in the probable cause affidavit.
All right. So, based on the language in the probable cause affidavit, there is concerns for the safety of the community, and based on that, I am going to impose a bond of $20,000. I'm gonna put him on a level 1 GPS, level 1 pretrial supervision, and Mr. Richard, when you post your bond, you're to have no firearms, no weapons, no ammunitions. Do you understand that, sir?
Yes, ma'am.
And, Your Honor, just based on the nature of the allegations, would also ask that include explosive devices.
Or explosive devices.
Okay.
All right. All right, good luck, sir.
Thanks.
Michael Kenny. Or if Miss Eubanks is back.
I don't know if she is or not, Judge.
All right. Michael Kenny. Mr. Kenny, you are before the court. Count 1 is possession of heroin. Count 2 is failure to wear safety belts. That's traffic infraction, not for magistrate.
Yeah.
I do find probable cause.
Judge, right now, nothing to add. I'm getting the phone number of his family to help him post his bond.
All right, Mr. Kenny's bond is $1,000. Good luck.
Okay, I'll call him right after. Thanks.
Timothy Fullwood.
And what, Judge, a phone order just in case on him?
Sure. Timothy Fullwood.
He's here, Judge.
Mr. Fullwood is before the court. It's a misdemeanor KPS matter. Is count 1, and count 2 is a violation of parole. That's a no bond hold. And so he should be going before the parole board shortly. I do find probable cause. The bond on count 1 is $1,000. Good luck, sir.
Jail is asking for a case to be called out of turn. It's a few more cases down on your docket. it said Jose Izazari on page 20.
Which,
Is this not him?
He's here, Judge.
Jose
Yes, ma'am.
Irizarry?
Yeah, he's coming up, Judge. Be careful. Don't worry, take your time. I'll move on. It's all right.
Mr. Irizarry is before the court. Count 1 is a possession of weapon or ammo by a convicted felon, and count 2 is false report or bomb explosive. And I do find probable cause. Does the parties wish to be heard as to bond?
Yes, Your Honor. On count 2, I'm going to be requesting a $10,000 bond. I mean, on count 1, a $10,000 bond. On count 2, $25,000 bond. Pretrial release with a GPS monitor. No firearms, weapons, or ammunition. Your Honor, first I would note his history. His criminal history has violence in it. 2014 battery, that was domestic in nature against a different alleged victim. 2012, he was convicted of child abuse. 2004, burglary of a conveyance with battery. I would also note, I'm concerned, Your Honor, that not only did he make threats to kill the victim by shooting her, he stole her firearms, knowing he's not even supposed to be in possession of firearms to begin with. They weren't recovered until 2 days later. I would also note the statement he made to law enforcement in the supplemental report that he concealed carries a 9mm on a regular basis.
Okay.
Judge, in speaking with Mr. Zari, he's contesting some of these allegations, so he's looking forward to having his day in court. Having said that, Judge, he's 35 years old. He's been living here in South Florida for approximately 20 years. What he does, he's basically self-employed, does side jobs as far as painting motorcycles and vehicles. Unfortunately, he was in a very, very bad accident about a week ago, in which he's injured, and that's preventing him from working at this time, Judge. Having said that, Judge, he does have family that reside here in Broward County, specifically his mother, Patricia, who I'm going to be reaching out to after court. From what he informed me is he doesn't know exactly what she does, but from what he says, she only works part-time and has very limited financial resources. So what I'm going to be asking, Judge, is on Mr. Irizarry's behalf, a $5,000 bond on count 1 and a $5,000 bond on count 2. Make a total request of $10,000 on his behalf, and we're going to ask you to sign a photo order so we can photograph the injuries of Mr. Irizarry. Thank you.
All right. I do find probable cause, and based on the allegations in these two affidavits that has been presented to me, I find that a reasonable bond is $10,000 on each count with the GPS, and no firearms or weapons or ammunition. Level 2. All right, good luck. Yes, and I'll sign the order.
Before he goes, just so we could hear the court advise him no contact with.
Mr. Irizarry,
Mr. Rosario?
Just so you know, sir, no contact with the victim is in this case. That means no phone calls, no text messages, no third-party contact. Okay?
Yes, yes, Your Honor.
All right.
Yes, Your Honor.
All right, good luck, sir.
And Judge, whenever you're ready, Ms. Eubanks is here.
Okay.
For the docket, I believe, waiting on her private attorney.
Oh,
Yes, I spoke with him. He does not represent her at this time.
all right, Gloria Eubanks. What's the name of the attorney that you said was representing her?
John B.
All right, Ms. Eubanks, you are before the court for one charge of grand theft. I believe you represented that you had an attorney, John David. Someone has contacted that person who said that he does not represent you on this case. So you are before the court today for a grand theft charge, and I do find probable cause.
One moment, Judge.
Michelle, do you have any notes on her other than this pending theft? Eubanks? I said, yeah, other than that. What's it? The misdemeanor?
Thank you, Judge, for giving me that opportunity. We're ready to proceed on Ms. Eubanks.
All right, state.
Oh, Your Honor, I'd be requesting that the court keep the bond in place. Ms. Eubanks is currently out, I believe, on a $100 bond from February, where she allegedly stole a total of 15 cans of baby formula at the same Target that she's accused of stealing baby formula from in this case.
So there's an open case with the same allegations?
Yes, ma'am.
Okay.
Just different, lesser amount.
Okay.
Judge, when is the date of this offense? Ms. Eubanks a little...
This allegedly occurred about 2 weeks before her last arrest.
February 27th.
That's when the report was written,
That was
Your
the
Honor.
first one?
The 31st and...
Okay.
This incident occurred on the 31st and February 5th.
Okay.
Judge, from what Ms. Eubanks advised me, at this time, she's not in a position to post a bond. We're going to be asking for Ms. Eubanks to be released on pretrial release. My understanding is she lives in Pompano Beach by herself. She's 59 years old. She is applying for disability. Right now, she will promise to come back to work, but unfortunately, there's nobody that's going to be able to afford to post the monetary bond. I believe her daughter helped her out last time and helped post the bond, and from what she says, right now, her daughter financially cannot. So at this time, we're asking for the court to consider releasing Ms. Eubanks on pretrial release on this case.
How much do we know how much bond she was out on the first case?
25.
All right, I do find probable cause. I am going to leave the bond of $1,000 in place. Good luck. Trey Tate. Yes.
Mr. Tate is here, Judge.
Okay. Mr. Tate is before the court for one count of burglary with assault or battery. And I do find probable cause.
And, Your Honor, the state is going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes, relying upon the probable cause affidavit and the incident report authored by Deputy Dillman. Guys, noting the allegations would satisfy the elements of burglary with the battery. This allegedly occurred in the victim's home, that Mr. Tate forced his way in, having no legal authority to enter her home, and then physically attacked her. There were photographs taken of her injuries, which were notably visible swelling on the right side, on her right eye, blood dripping down her face. There's physical evidence of a struggle, noting the picture frames were knocked off the wall by the doorway where he forced himself in, and blood on the wall.
And Judge, we would object to the court making a finding of proof evident presumption great at this stage of the proceedings. Having reviewed the affidavit and everything else, it appears that this is a dispute over who was going to have custody of their child. It appears the family has no real custody agreement in place. The report does note that it's not unusual for the child to be with Mr. Tate, but there are no concerns for the child's safety. Those are words from the actual affidavit itself, which would lead me to conclude or to argue to the court that a no bond hold is not appropriate in this particular case. I do believe that an order for Mr. Tate to stay away from the alleged victim in the case would be very appropriate. But I do not think a no bond hold is necessary here. Also, I would point out that proof evident presumption great is the highest standard of proof that we have in the criminal justice system, higher even than proof beyond a reasonable doubt. The state has introduced nothing else other than an affidavit to this court, and while the case law does hold that that is sufficient, it isn't always sufficient. And this court does not have to make a finding based on proof evident presumption great because the state failed to do anything other than introduce an affidavit. They called no witnesses, introduced no physical evidence. There were supposedly photographs taken of this victim. Those have not been introduced for this court to look at. So basically, they've done absolutely the bare minimum to ask the court to make this finding on the highest standard that we have in criminal law. So I would ask the court, first of all, not to make a finding of proof evident presumption great. If over our objection the court does make that finding, then I would ask the court under these circumstances to exercise its discretion and set bond for Mr. Tate.
Your Honor, I would just note that the evidence does not support any type of allegation that this was some type of custody transfer, Your Honor, considering that he forced his way in at 11 o'clock at night, the child's 6 years old, and just noting that based on the sworn statement from the victim, she didn't want to let Mr. Tate into her home.
And as it says, the victim and the offender do not have any formal custody arrangement, and it is normal for the child to be with the father. There are no concerns for the child's safety with the father. He watches him several days per week, usually.
This isn't a child abuse case. My concern is for her safety.
All right, I've had an opportunity to review the complaint affidavit and also the incident investigation report. And what has been presented to me today is not a child abuse case. The allegations are towards the victim, who is the mother of the juvenile that's just mentioned in this affidavit. Based on the allegations, there is report that the victim did give a sworn statement, and based on the report from the officer that she did have a visible swelling on the right eye and blood dripping down her face, and that the room had the appearance that there was a struggle. I do find probable cause, and I'm further going to make a further preliminary finding of proof evident presumption great, and Mr. Tate will be held no bond until further order of the court. I will order no victim contact. Also, that means no phone calls, no going to the resident, no third-party phone calls until further order of the court. All right. Tamarick Dominic.
She's approaching, Judge.
All right, you're before the court today for count 1 is grand theft and count 2 is possession of MDMA. I do find probable cause.
Judge, in speaking of Mr. Dominic, unfortunately, there's no way he's going to be able to afford to post this monetary bond. At this time, he informed me he's not working. He's currently looking for employment. He's been living here his whole entire life. He lives in Lauderdale with his mother. His mother is on disability. And also, Mr. Dominic helps his mom out. She's going through dialysis. And, Judge, and that is why we're asking for the court to consider releasing Mr. Dominic on these nonviolent offenses on supervision with pretrial release.
Your Honor, the issue I'd have, and I would object to pretrial, is when he was placed on pretrial in his last case, and that was a 2016 possession of PVP, he had to be picked up on a warrant for violating pretrial. He was supposed to submit to drug and alcohol evaluation. He never provided pretrial with any type of proof that he submitted to such an evaluation. He also failed to continue to call his pretrial officer 2 times a week. At the time of the writing of the affidavit for the warrant, pretrial had no idea about his whereabouts.
Okay. All right, I do find probable cause, and Mr. Dominic's bonds will remain in place, $1,000 on each count. Omar Walker.
Mr. Walker, come on up, please.
All right, Mr. Walker, you are before the court today for grand theft, and I do find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Walker on pretrial release. Right now, unfortunately, he is homeless and he's not working. He advised me he's been living here his whole entire life. He does have family, and that his aunt specifically that lives in Fort Lauderdale, that he can use her mailing address in order to receive future court notices, so he can be sure to come to court. I believe this grand theft involves a TJ Maxx in which the merchandise was recovered. So just considering this is a nonviolent offense, that is why I'm asking for the court to consider releasing Mr. Walker on pretrial release.
Your Honor, I'm showing he, let's see. He was released from jail December of last year, and that was on a capias for a theft. He just pled out and got released from jail after a day as a special condition of his probation for possession in early February this year for possession of substituted cathinones. He had another theft last year, aggravated fleeing and eluding at a high rate of speed last year with a violation of probation. Showing. Another arrest on a capias failure to appear last year on a theft. Further.
Okay. All right, I do find probable cause, and Mr. Walker, your bond is $1,000. All right, Mr. McLawrence. Good morning. I don't know the pages, but I'll call them in the order that I have. And Ralphine Joseph.
He's on page 9 of the docket.
All right, Mr. Joseph, you are before the court for two municipal ordinance violations: disorderly intoxication and trespassing. I do find probable cause. What does Mr. Joseph wish to do?
Judge, he wishes to resolve this matter.
Resolve it.
All right. Mr. Joseph, your sentence will be adjudication and time served if you wish to resolve these matters.
Yes, ma'am.
All right, as best as you can, please raise your right hand. You swear or affirm to tell the truth?
Yes, Your Honor.
All right, you can put your hand down. Do you understand everything that's going on here today?
Yes, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
You understand you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes.
And is anyone forcing you to resolve your case?
No, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Joseph?
No contest.
I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you.
Christopher Jackson.
He's on page 9.
All right, Mr. Jackson, you're before the court for misdemeanor. It's a KPS on a trespass charge. I do find probable cause. What does Mr. Jackson wish to do?
Judge, he wishes to resolve this matter.
All right, Mr. Jackson, do you want to resolve your case today?
Yes, ma'am, I would.
All right, your sentence is going to be adjudication and time served. Do you understand that?
Yes, ma'am.
All right, please raise your right hand. Are you swear or affirm to tell the truth?
Yes, ma'am, I do.
All right, sir, you can put your hand down. Mr. Jackson, you understand that you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes, ma'am, I understand.
And have you ever been treated for a mental or emotional illness?
No, I haven't.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am, I understand.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you much.
You're welcome. Stanley Harden.
Yes.
Mr. Harden is on page 10 of the docket.
All right, Mr. Harden, you are before the court for count 1 is possession of cannabis 20 grams or less. Count 2 is a municipal ordinance violation, and count 3 is a misdemeanor KPS. So,
And Judge, on the state offenses, Mr. Harden declined to serve as a public defender.
okay. And on the municipal ordinance, what does he wish to do?
Judge, he wishes to resolve.
Resolve. This one of the time served, Your Honor. I just coming from the laundromat and riding down the street. Police just stopped me.
His name is Stanley Harden. He's on page
I
10.
had a beer.
Okay, Mr. Harden. Okay, that's enough.
All right.
Okay.
So you want to resolve the municipal ordinance matter as well as the state matter. Is that correct?
Yes, ma'am.
All right. So, it's to possession of cannabis charge, counts 1 and 3.
Judge, obviously, I'd be asking if the court would withhold, given that he's indicated that he has started working.
But that would be the offer from the state.
All right. So the offer is withhold adjudication and court costs on all the counts, Mr. Harden.
Thank you, Your Honor.
That's the offer. Don't go anywhere. Don't go anywhere, Mr. Harden. Mr. Harden.
I'm sorry.
I see that you're in a rush. That's okay.
Sorry about that.
What plea do you wish to enter?
Oh, no contest.
All right, I accept your no contest plea, and your sentence is a withhold adjudication and court costs.
Okay, thank you, ma'am.
All right. Anthony Maza.
He's over in North Broward. He's on page 12 of the docket.
All right, Mr. Mazza, yeah, it's an alcoholic beverage violation. It's on a capias. What does Mr. Mazza wish to do?
He wishes to resolve, Judge.
All right. Mr. Mazza, if you wish to resolve your case today, it'll be a withhold adjudication and court costs.
Thank you, yes, ma'am.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea and your sentences of withhold adjudication and court costs. Adam Berman,
He's on page 12, and he's at the main jail, Judge. He has a little difficulty standing up. That's him. We can see him there. He has some trouble standing up, Judge.
okay.
Thank you. Thank you, sir.
All right, Mr. Mazza, you are before the court for an alcoholic beverage violation. Mr. Berman, I'm sorry. Mr. Berman.
Yes, ma'am.
And so I do find probable cause. What does Mr. Berman wish to do?
Judge, he wishes to resolve.
All right, Mr. Berman, I'll offer you a withhold adjudication and court costs to resolve your case. Is that what you wish to do?
Yes, ma'am.
And what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea and your sentences of withhold adjudication and court costs. Good luck.
Thank you.
Page 12.
Jesse Roberts.
He's on page 13. Jesse Roberts. Judge, I let the court know that I did speak to Mr. Roberts. He seemed a little confused as to what this charge was about. I had an opportunity to look it up, and it's a February possession of marijuana allegation against him. And he missed court, so a warrant was issued for his arrest. So that's what this case is about, Mr. Roberts.
All right, sir.
All right.
I just did.
What does Mr. Roberts wish to do?
Do you want to resolve the matter, Mr. Roberts, now that you know what it is?
Yes, court tomorrow if he wants to
Yes,
go to.
let's resolve it if we could.
Okay.
All right. All right, I'll offer a withhold and court costs.
Okay, Mr. Roberts, do you want to accept that?
How can we resolve this case, though?
The judge just offered you a withhold, time served, and court costs. Do you want to accept that?
All right, yo.
All right, please raise your right hand, sir. As best as you can. All right, do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Roberts, do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No. I don't know what the case for, but if it's resolved, we can just resolve it.
All right.
I don't know what the case for.
All right. Okay, stop talking, sir. I find probable cause. Your bond is $250.
Huh?
You can resolve it before your division judge. Patrick Wilson.
He's on page 15 of the docket, Judge.
Mr. Wilson is before the court for municipal ordinance violation. It's a petty theft charge. And I do find probable cause. What does he wish to do?
Judge, he would like to resolve.
Does he have any prior petty theft charges? Do we know? Has that been discussed?
His name is Patrick Wilson. His VCCN is 865496.
He's got multiple theft convictions in the past, both in Florida and out of state.
All right, so Mr. Wilson, if you wish to resolve your case, it's gonna be adjudication and time served. What do you wish to do, sir?
Resolve my case.
What plea do you wish to enter?
No contest.
All right, your sentence is adjudication and time served. Good luck, sir.
Mr. Wilson,
Thank you.
Mr. Wilson, Mr. Wilson, before you go, you should know that if you pick up another petty theft, no matter how small it is, no matter how insignificant it is, you could be charged with a felony grand theft because you have more than two petty thefts, more than two prior petty thefts. Okay?
Yes, sir.
Okay, then take care.
All right, court's gonna take a brief recess. let's continue with Brian Carter.
Mr. Carter, come on up, please.
Okay, Mr. Carter, you are before the court. Count 1 is possession of heroin. Count 2 is possession of drug paraphernalia. And count 3 is a misdemeanor violation of probation. Count 3 is a no bond hold, and I do find probable cause. Your bond on count 1 is $1,000, and you're going to your division judge tomorrow at 9 a.m. Good luck, sir. Kendrick Johnson.
Mr. Johnson, come on up, please.
He's bonded. Okay. All right, so Mr. Johnson, you are before the court for count 1, possession with intent to sell, manufacture, or deliver cocaine, and count 2 is a misdemeanor capias. I do find probable cause, and I've been told that your bond has been posted, sir. Good luck.
Good luck, sir.
Eric Flewellen.
Mr. Flewellen, come on up, please.
Sir, you are before the court. Count 1 is a misdemeanor violation of probation. There's a bond of $1,000 that's been attached to that. And counts 2 and 3 are felony capias matters. Those are both no bond holds and not for magistrate. I do find probable cause. And you will be before your felony judge on April 10th and the misdemeanor division on April 11th. Good luck, sir. Francis Kagan.
Bonded.
Kelvin Lanier.
He's approaching, Judge.
Right, so, all right, so Mr. Lanier, since you're here, I just need to let you know that counts 1 and 2 are a bond surrender on your felony charges. Those are not for magistrate. And then there's a felony violation of probation, which is a no bond hold. And you're going to your division judge tomorrow at 8:30. Good luck, sir. Charles Barkley.
Mr. Barkley is approaching, Judge. He's here on me.
Mr. Barkley, you are before the court for count 1 is possession of methamphetamine, count 2 is possession of MDMA, and count 3 is possession of drug paraphernalia. I do find probable cause.
Show you out of state. Wait a minute.
Judge, we're going to be asking first to consider releasing Mr. Barkley ROR.
Your Honor, state would oppose. I don't believe Mr. Barkley has ties to the community. I'm showing an Alabama address.
That is correct, Judge. He's here for work purposes. He's a welder. My understanding is he contacted his wife. His wife was in talks with the bondsman, and because he's out of state, bondsman, I believe, who she spoke to, wanted to charge the full amount. And for what he advised me, that's going to be a little tough. He advised me he only has one prior offense in his whole entire life, which was a misdemeanor cannabis charge, I believe, when he may have been 18 or 17 years old. So, Judge, I'm asking for the court to consider a straight ROR, or in the alternative, then at least ROR count 3.
All right, so Mr. Barkley's got, I do find probable cause. I will ROR on count 3, but I'm going to leave the bonds in place on counts 1 and 2.
Yes, sir. Okay, I'm going to call Ashley again, okay?
All right, Jack Hunter.
He's a person, Judge.
All right, Mr. Hunter is before the court for distributing or delivering cannabis. Counts 2 is distributing or delivering scheduled drug, and count 3 is possession with intent to sell or deliver a scheduled drug. I do find probable cause.
Nothing to add from the defense. I'm going to be contacting his family after court.
All right. Yes.
He's currently on pretrial supervision in case number 17013964 CF10A, burglary, conveyance occupied, count 2 battery. At this time, we're requesting a revocation of his supervision.
What level of supervision was he on?
We literally just
He was on GPS, open schedule.
Oh, okay. All right. Mr. Hunter was on pretrial supervision on case number 17013396 CF10A for burglary for conveyance and count 2 a battery charge. Based on the new arrest, I am going to revoke his pretrial supervision and he's going to be held no bond on these charges.
Judge, I'm going to be asking the court to consider not imposing the most severe sanction that the court could possibly consider. Just in judging by the case numbers, a 2017 offense. Judge, my understanding is he was, I believe, out on pretrial standard, if I heard correctly.
No, he was out on a level 2 GPS.
No, I was out on open schedule.
That's level
3.
No, that's level 2.
And Your Honor, just, if I may, to give you a little bit of history before he was ultimately placed on pretrial. He was arrested on the burglary in 2017. He then, actually, I'm sorry, it was a 2017 case that he was arrested in 2018. He then got arrested on new charges and had his bond revoked on the burglary, ultimately getting a bond on that, bonded out again. He then failed to appear and had a capias issued on the burglary, to which his judge then finally placed him on pretrial release of the GPS monitor. As you can see, he's been arrested multiple times since being arrested on that burglary.
And this new arrest occurred while he was on level 2 GPS.
Yes.
So,
one final thing. Now I've been corrected by the court. I didn't hear it before. He was on level 2. I'm going to be asking now the court consider releasing him on level 1 house arrest. And my understanding is hearing what the state just said that he previously violated from what Mr. Hunter advised me. He actually surrendered when there was an outstanding warrant. So, Judge, I'm asking you, based on the fact that he surrendered himself, based on the fact that he was on a level 2, and now we're asking for a level 1, that the court consider doing that rather than holding him no bond and imposing the most severe sanction on his behalf.
that's going to be denied, and as to the new charge, the bonds will remain in place. Robert Davis.
No problem, Your Honor. Medical reset.
All right, thank you.
You're welcome.
Gerald Scarola. Is he back?
He's still on loan, Judge.
Okay. And Chase Alberg.
Hold on, Your Honor.
All right, Mr. Alberg, this is you're before the court for a robbery with a firearm.
It's, if I may, Your Honor.
Yes.
It's a technical. When he was arrested on the warrant from Judge Colra, the charge was for attempt. Judge Bober set a $50,000 bond on that count. We filed it as the attempt. It's now, I believe, before Judge Bober. No, it's before Judge Lynch.
It looks like Judge Colra. No?
No, he signed the warrant. That's why they have Judge Colra's name there. Your Honor, I would just ask that the $50,000 bond be placed back on him.
Okay. All right, Mr. Alberg, I do find probable cause for robbery with a firearm, and your bond is $50,000.
Thank you, Your Honor.
All right, good luck. And then Quentin Kersey. Okay. All right, this is a charge number 7, and it's abuse of elderly or disabled adults without harm.
Your Honor, this is a change of charge. It's an upfile from a battery. The convenience bond was left on the battery at $1,000. Your Honor, in this situation, because of the upfile, and I provided the court and defense counsel with a supplemental report going over the allegations. Your Honor, I believe these allegations are so aggravating that I am going to be requesting a bond increase. Noting the allegations are that Mr. Kersey went into the room of someone that was staying at this rehab and nursing center. While they were sleeping, he choked the individual with both hands, causing him to almost lose consciousness. He threatened that he would come back and do it again. I would note that law enforcement spoke to Mr. Kersey's uncle, who has known him all his life, and he stated that he came to visit him, and he admitted that he choked the victim, and that he said he would come back and choke the victim again. I'd be requesting a $10,000 bond, no victim contact. I can advise the court. Mr. Kersey, he is being held no bond on a violation of probation. Additional priors include possession of substituted cathinones, that's what he's on probation for. Unlawful use of false name ID last year, possession of heroin and cocaine. 2016, resisting without violence, criminal mischief. 2016, resisting with violence. 2016. Nothing further.
Okay.
As the state points out, Mr. Kersey is currently being held no bond on count 5 and count 8, both of which are violation of probation. That being said, I think the bond that the state's requesting is too high. Obviously, Mr. Kersey will have to go in front of his division judge to resolve the no bond holds. I'd ask the court to consider a $5,000 bond.
Okay, finding probable cause, I am imposing a bond of $10,000 and no victim contact until further order of the court. All right, good luck, sir. Okay, I believe we are at the end of our docket for the morning.